in all business-related civil litigation. Throughout his career, he has defended design professionals and has participated in many landmark legal cases protecting design professionals. John is highly rated in the legal community, receiving awards such as Super Lawyers, Legal Elite, and Vegas Inc.'s Top Attorneys for Real Estate. Jeremy Kilber joined the U.S. Navy after graduating from high school in North Dakota and served in the Navy's nuclear submarine force as a sonar technician. Upon completing his service in the Navy, Jeremy earned his bachelor's degree and Juris Doctorate at University of Nevada, Las Vegas. He has a wide range of legal experience, including construction defect litigation, professional liability defense, family law, estate planning, veteran advocacy, and civil litigation. While Jeremy has experience in multiple areas of the law, he is particularly proficient in his defense of design professionals. Over the last decade, Jeremy has secured in excess of $2.5 million in judgments for his design professional clients. He has been recognized by Vegas Inc. as a top lawyer and in the fields of construction and insurance. So John and Jeremy, you may give your presentation. Oh, and John, you're muted.
Hello, can everyone hear me now? All right, good afternoon, thank you. To everyone here today, we're going to be talking about probably your most exciting topic. At least a lot of our clients have always found it to be exciting. This is how the law comes into play with respect to the work that you guys do. And so today's presentation, we decided rather than focus on one or two little items, we wanted to kind of paint the whole picture for everyone. That's why we call it Navigating Contract and Legal Issues Facing Nevada Design Professionals in 2020. And so the next screen I'm going to move to, this moment. Okay. This is the list of topics that when we sat back and thought about today's presentation, we thought that this will address what we consider to be the general total history of issues that design professionals will face at some point in their career. And the topics we'll be discussing here today, and I want to be very clear, each one of these topics could take hours on end. But for today's purpose, we wanted to talk more in the overall perspective. We can go into each one of these topics with significant time discussing those items, but we felt that rather than point to one item, for example, certificate of merit, we wanted to touch upon all items so that by the time this presentation is over, everyone will at least have some knowledge of some of the issues and topics that they're going to have to be dealing with. For example, the first topic we're going to start with is statute of repose. We'll discuss those items. As we go down to certificate of merit, ADA non-delegable duty issues, Chapter 40. These will be general discussions and issues that one or more of you will face or have faced. First topic I want to talk to you was statute of repose. Statute of repose in the state of Nevada is governed under NRS 11.202. So the first question is already on the slide. What is a statute of repose? At its base definition, it is the outside time period that a claim can be brought based on a defect in design, planning, supervision, observation of construction, or construction of an improvement. Here's the kicker. No claim can be brought for these particular items if it's past the statute of repose time period. And it starts from the date of some called substantial completion of the improvement of the defect, either an injury or wrongful death caused by that defect. A very good starting point would be the certificate of occupancy. There are other categories, but that's usually typically the one that sets what we call the clock starting. And so the reason I started this as the first topic of discussion is Nevada has changed its statute of repose. Before October 1, 2019, the statute of repose was 6 years. This means if you had a project in which you performed design services 6 years prior to October 1, 2019, and that date had expired, the 6-year time period expired, they cannot bring a claim against you. However, on October 1, 2019, it has gone to 10 years. Now, some of you design professionals may recall the statute of repose used to be some crazy 6, 8, 10, and even sometimes 12-year time period in which a claim can be brought. That means projects that you did 10 years ago, all of a sudden resurrect. People do not have documents. Witnesses are gone. Nobody really has a recollection other than maybe a set of plans as to what was left with respect to the given project. And because of the confusion, a lot of the courts defaulted to the 10-year statute of repose. Well, in roughly around 2015, that was changed to 6 years. It greatly brought down a lot of the construction defects that we've seen, claims, really old projects. Those started going by the wayside. We were very successful in eliminating a number of projects based on the 6-year repose. Well, sorry, people. It is now 10 years in the state of Nevada. The significance of that is a project that used to be excluded is now included. And everyone should be wary that a project that you thought was stale, was gone, no longer relevant, those projects are now back in play. Someone can bring a lawsuit against your design so long as the substantial completion time period is now 10 years. And this is what we want to start off explaining to everyone, that there is a change in law. And certainly one of the critical elements of this is your document retention policy. Some of you may have had a policy that was based on the old statute of repose. Maybe some of you don't even have a policy. Under the new statute of repose since October 1, 2019, we would recommend, and most lawyers would recommend this as well, that you modify your retention policy of documentation, save your projects now up at least 10 years. Because irrespective of the project, there is a potential of a lawsuit with 10 years now. And because of that, your retention policy should match that. It helps you in the event that a lawsuit is brought on an old project that you thought was gone. Now you have documents and records to address that. And also, one more thing to note, the change in law is under AB 421. Within AB 421, there's something called retroactive application. So retroactive application is the legislature's ability to apply that law to projects that occur before October 1, 2019. Most statute of repose without retroactive application would start on October 1, 2019, which means you would be fined. Unfortunately, in Nevada, they include a retroactive application, which means even if the project, the claim is brought for a project that's before October 1, 2019, retroactive application allows that claim to survive and be brought against you. So this is our first topic. Again, this could in and of itself be a very long presentation on just this one particular item, but please note, for your knowledge, edification, your retention policies, Nevada is now a 10-year statute of repose. The claim must be brought within 10 years. So when we're talking about substantial completion earlier, I gave you a general description. This is one of them: certificate of occupancy, notice of completion, final building inspections. Those are the three categories. Critical to note, substantial completion is the latest. So if you have a notice of completion on October 1 and a certificate of occupancy November 1, the date that the court will apply is the November 1 date. Another thing to note is this does not apply to fraudulent concealment. So I know none of you would ever do this, but if you had a competitor that you knew did this, if they fraudulently concealed something, you don't get the benefit of a statute of repose if it's discovered in year 11, for example. So what we do is, if you see the very last bullet point, you want the clock to start. It's 10 years, but you want it to start as soon as you can, as quickly as you can, So we always recommend to design professionals to issue a notice of substantial completion, get that clock moving, get some sort of a documentation to get that tenure moving forward. Because what happens is we find contractors and owners, they'll squat on this. And so even if a project's been done, let's say in February, they'll squat on the certificate of occupancy until June, July, sometimes as long as 6 months. I'm not saying they're doing it for pure legal, tactical reasons, but we encourage our clients that they should push to get that clock moving forward. Again, as stated, October 1 was the start date. It is now 10 years. It's retroactive, and potentially, now this is interesting. We have a pending writ before the Nevada Supreme Court on the definition of whether stale claims should be allowed. These are claims that may, under the prior 6-year repose, be excluded, but now are resurrected under the retroactive application. We have a writ arguing that stale claims from a constitutionality perspective should not be allowed based on due process, based on the elimination of a defensive right. We don't know how the Supreme Court will rule on that, but we put that in here just as a topic of discussion. And again, the retention policy, we've already discussed that. Okay, next is certificate of merit, and I think Mr. Kilber here would like to address that issue.
Jeremy, you're muted. Jeremy, you're muted.
All right, we'll try this again. So one of the things we didn't talk about before we really got started was when we're going to address questions, and we can either address it at the end of a topic or at the end of the presentation. We're going to try to loop in as many as we can as we go through a topic. So if the questions come in and we see that it pertains to something we're going to discuss, if we don't respond to your question right away, it might be because it's later on in the presentation. So that's what we're going to do with questions. So as far as certificate of merit goes, as you all know, Nevada has a certificate of merit statute for residential projects and one for non-residential projects. And what the certificate of merit does or requires, or the statute requires, is when a party is going to sue a design professional, they have to retain an expert to review the facts of the case and look at the scope of work provided by the design professional and affirm that there is merit to the claims that will be asserted against the design professional. That has to be served concurrently with the service of the complaint and the action. If it's not served along with the complaint, it provides an opportunity to extricate our design professional clients from the case based on the failure to comply with the affidavit of merit statute. And some of the issues we've been seeing come up in this regard, most often than not, plaintiff parties are not typically savvy to the requirement to file a certificate of merit. And so we see a lot of complaints filed against design professionals that don't contain the certificate of merit along with the complaint. However, once we can move for dismissal then when we don't get their certificate of merit, and the courts typically will allow a plaintiff party to refile their complaint against the design professional after they obtain their affidavit of merit or certificate of merit, unless the statute of limitations or repose has run. And just real briefly, I saw that there was a question about the difference between a statute of limitations and a statute of repose. A statute of limitations is a period of time to be able to assert your claim after it's discovered. So in the instance of a design issue, they would have a period to identify the claim and bring the action within 6 years of the discovery of their claim. However, a statute of repose sets an outside absolute limit where all claims are barred once you reach that statute of repose. So a limitation period is typically shorter. Statute of repose period's longer, and it covers the entire duration that a claim could be brought. Typically, what you would see this under, why it's important, is personal injury cases that arise from a design. A statute of limitations for a personal injury is 2 years. So they have 2 years from their injury to bring their case against the design professional. If they don't bring it within that 2 years, they're barred. Now let's say that a project is ongoing and well, give me a circumstance where a statute of limitations would be
Like personal injury.
Yeah, personal injury is the most common area where a statute of limitations would probably be triggered before a statute of repose. The statute of repose is looking to maintain, to give design professionals and others subject to a statute of repose some sort of finality. So you're not always looking back, worrying about whether in 20 years from now there's going to be a lawsuit arising from your project. So statute of limitation is shorter term, statute of repose longer term, and it's a drop dead end of the case if filed after the statute of repose. Okay. Right now we've got a case up at the Supreme Court that's pending with respect to the certificate of merit. And the issue up on appeal right now is the wording of the statute and whether the statute requires that a plaintiff or complainant needs to obtain a certificate of merit from an expert practicing in the same field of practice as the design professional against whom they're offering their opinion. Most courts in Nevada have interpreted the statute to say that you need a like expert to opine on the same scope as the design professional being sued. Where it gets a little sketchy is when you have multiple design professionals being sued in one action. And there's been an occasion where a plaintiff has obtained a certificate of merit with respect to one single design professional named in the case, and they rely on that affidavit of merit to say an expert has opined on an issue in the case, saying that there's merit to the claims, therefore everyone should be brought into the case under that affidavit. That decision hasn't been made by the Supreme Court yet. Most district courts that we've encountered on this issue require a separate expert opinion for each area of practice of the design professionals being sued.
Excellent.
And I think we covered all this. And John's going to go on with the Americans with Disabilities Act, and I'm going to look at your questions and see if we can send out some answers.
Okay, hopefully everyone can hear me. We're still kind of working through some of the technical areas on this, so I apologize. We can, again, spend a lot of time on Americans with disabilities. I really wanted to focus on a very limited area, which is non-delegable responsibility. Rolf Jensen v. District Court. This is a case in the state of Nevada where our firm was successful in eliminating common law indemnity claims that are brought by a project owner against the ADA, in this case, the ADA consultant. And we successfully argued that owners in the state of Nevada and elsewhere, based on a federal case, were not allowed to shift their responsibility to comply with the ADA against the design professional that they hired, in this case, the ADA consultant. This is still the law of the land in Nevada. However, we are aware of a Ninth Circuit case that has recently manifested in California, City of Las Vegas. City of Los Angeles v. ACOM. It's a Ninth Circuit case. In the Ninth Circuit, they have stated that a owner can bring contribution. Now, indemnity and contribution, we touch upon this later, but I'm going to bring it up now since I'm bringing it up in the context of this case. Indemnity, think of it as the shifting from A to B, full responsibility. Contribution, think of it as partial shifting. So not the full amount, but partial. So in the Ninth Circuit, which is not the law in Nevada yet, there is a right to seek contribution, meaning a part. In other words, the owner cannot shift its full responsibility of compliance onto a design professional. Now, we caution all the design professionals in this presentation. If you are going to sign a contract and you are going to take on the responsibility of ADA compliance, you better have on staff an ADA consultant or specialist with ADA knowledge. Or alternatively, you should hire an ADA specialist, or another option, which is have the owner, developer, whoever is the prime, hire the ADA consultant, because ADA is a little tricky. It's got all these nuanced requirements, and some of it's negotiable and some of it's not. We just see in situations, especially if you have a large scale project, you need to have specialists, and we recommend that highly. Do not call yourself an ADA specialist unless you do have on staff an ADA specialist, somebody with ADA knowledge who can properly design in accordance. We did note that owners are attempting to shift this burden in their contracts. They'll say, if you do have an ADA responsibility, the owners in their contracts are inserting language that says you'll be fully responsible. Well, this is the problem. It's against the law, at least in Nevada, as we currently stand. And so we just wanted to touch upon this. Again, this is an entirely new topic that we can go for the next hour or so, but we wanted to hit some of the high points. Is there any question?
Ask if is everyone seeing the PowerPoint? Is it still reversed?
Can everyone see the PowerPoint? We had a little bit of a technical issue. Is there a response?
It's still reversed. Yeah, it's reversed. So you're gonna have to.
How do I do that?
Wait, on my screen it shows up the right way.
So the people that are saying the PowerPoint's reversed, our screen shows that it's working. Is everybody in the same situation?
I'm seeing it just fine.
Okay. How do we change this then? Yeah, give us one moment. We'll try to figure this out. I apologize for that.
I'm seeing it just fine.
Should I get off the...
Some people say it looks good. Some people say it's...
Okay, so we have, interesting, some people are fine with what's shown, some are not, some are reversed. We sent out this PowerPoint presentation. If you have it in reverse and it's difficult to follow, I think the easiest way is to refer to the packet that was previously sent out. It's a copy of what we're going through, but we'll try to keep working on it, and maybe hopefully we can fix the problem. Apologize for that. Okay, now, next topic is something called Chapter 40. If most people say, well, what's Chapter 40? What is that, some book? Chapter 40 is the name of construction defect litigation statutes, specifically NRS 40.600 starts the Chapter 40. This is for residential projects. If you're doing residential projects, I am guessing you have a very good chance of getting sued under this statute for a construction defect pertaining to single-family residences, townhomes, and condominiums. The Chapter 40 statutes, and the good news is Chapter 40, as we term it, cases, have gone down in Nevada. They used to be all over the place for various reasons, some economic, some projects aren't being built. Some Chapter 40 lawyers have left the state. We don't see as many of these cases as we used to. Nevertheless, they're still around. We do see some lawyers start popping back up again on this Chapter 40 stuff. We've seen it in custom home properties. But this is the statute that generally you would be sued under if there was a design related to a construction defect in a residential property. The general obligations, and you may have been to a Chapter 40 seminar previously, the general obligations remain relatively unchanged. There is still the obligation to provide notice. So for some of you unlucky design professionals, you would get a letter from a contractor and owner putting you on notice. The letter is very generic. They'll say, well, these people allege some sort of a defect and it's allegedly somehow connected to your project. It's completely worthless. Nevertheless, the point of the letter is to check a box and put the case into the right to repair phase. This is where you'll have an opportunity to investigate, inspect the property, and an opportunity to propose a repair. In my decades of working on this stuff, I've never seen one design professional agree to do a repair because you do design. This is really for contractors, and even that is very rare. Most cases, like I say in the next point, is most cases they have a mediation. You go to the mediation and you're literally sitting there for a couple hours, nothing going on. The mediator comes in and says, okay, I don't know why you're here, but do you want to put up money? And we tend to say no. And they rarely settle. So then you go into a Chapter 40 formal litigation, and all of this is pretty much the same. We just wanted to kind of bring it back up. It is still around for those of you who thought it had gone into the dustbins of history. That is not true. The good news is we haven't seen an uptick in the number of Chapter 40 cases in the state of Nevada, but they're still around. And again, I would recommend that if you get one of these notices, immediately notify your broker, your professional liability carrier. They do come down. They would assign counsel such as myself to assist you. So moving on to the next topic is contract. This is a very important topic, and we broke it down. You may recall at the beginning of this presentation, we had a laundry list of items. Well, half of those items in that first column are related to contract. So rather than having a generic section, we just decided we'll just break it up. So first of all, contract, pretty straightforward, right? It's an agreement between two or more parties that create obligations that are enforceable under law. Generally, a writing is viewed as a contract, but you can have an oral contract. This is where two individuals, two or more, agree to enter into some scope of service for any given project. So all of you are pretty familiar with contracts. Let's talk about the different kinds. So we talked about oral, we talked about written. Well, why do you want to have written contract? And I know it sounds like a rhetorical question. The purpose of a written contract is to establish the rules of the game, we call it. But in this case, it's the relationship between yourself and your client, specifically the scope of work, your duties and responsibilities, the allocation of risks and rewards, and develops a framework for dispute resolution. And very importantly, insurance companies and Nevada law related to design professionals require it. You want to have a very good and solid contract, and it should be in writing. And very importantly, it needs to be signed. If the contract is not signed, it makes it very difficult to enforce some of the great terms and conditions you may have in it. And some of those we're going to go through. But please, we see it all the time. Somebody submits a proposal. It comes back unsigned. No one can ever find the signed copy. You need to get a good contract and you need it signed. If you don't have it signed, it is difficult to argue those provisions. So let's talk about, I touched upon it, proposal. Everyone knows about proposal. It's something offered for consideration or acceptance. Generally, we see proposals as bare bones. We're going to do some minimum amount of scope of work items. Most of proposals really fixate on costs and fees. That seems to be the big thing. And it's generally negotiated before the contract. Sometimes the proposals are incorporated into the contract, but that's usually the first step. And I'm sure everyone understands that. So why do you have a proposal? Again, a proposal is important to show that there was a meeting of minds, especially on scope and fees. And if you have really good proposals with a lot more detail on the scope, you can then incorporate that, which becomes part of the contract itself. Then you can refer to that proposal as a contractual right, a contractual definition of scope. And certainly your fees as well. You want to have good defined fees. You want to have as much favorable provisions you can into the proposal. And there could be a lot of really good protections, some of which we'll be touching upon, that you can incorporate into a contract. Now, incorporating a contract means it becomes an attachment, and when it becomes an attachment, it becomes part of the contract. So if you think of the contract in the AIA form, everyone knows what the AIA form, right? If you go in the AIA form, we always find there's missing provisions. There's some really good provisions in there, but there's a lot that's missing. You can incorporate your proposal with really good general terms and conditions, some of which like limitation of liability, waiver of consequential damages. Some really good stuff can be incorporated into even a generic form contract like the AIA, so long as it's referenced and incorporated as part of the contract. What we tend to find, generally speaking, is you will submit a proposal, even with awesome language, and the contractor, the owner comes back and says, no, I want you to sign my contract. And guess what? Their contract is always worse. It doesn't have the great language. They're not there to protect you. They're there to protect themselves. They're there to make sure that their claims are able to be brought against you. So when you submit your proposal, if you have good proposals with good protective language, we always recommend you incorporate it. It has a very good defined scope of work, very good fee arrangement, and if you can insert general terms and conditions as part of your proposal and they get incorporated into the contract, guess what? When they sue you, you can then turn to that proposal and say, aha, I'm capped at XYZ amount. Aha, you don't have this right. And some of the other items we talked about. So generally, we talk about what governs a contract or proposal. Contract is governed and should be expressly stated in event of a conflict. And this is an important point. There is something called a conflict resolution provision in contracts we find. So when you have this situation, now let me give you back that example we said where you send in your proposal with the awesome language, the contractor sends you his contract and it's not so great, right? But let's say you guys incorporate the contract, but then in the contract, there's an express provision that says when there's a conflict between the contract and the proposal, the terms of the contract will govern. So guess what? If you have a limitation liability provision in your proposal, but not in the contract, and the contract expressly excludes the limitation liability, says something in there shall be no limitation liability, and you have a contract that makes the prime contract primary, then guess what? You just lost your limitation liability. So pay particular attention to this provision that if there is a conflict between the documents, when you mirror them, you want your proposal or you want your great contract, you want your great terms and conditions to govern. And be very careful of your client's contract. It can supersede every one of your favorable provisions, excuse me. And I tell this to all my clients, please, contract is so critically important. You can avoid most lawsuits, and even if you get in one, you can eliminate a lot of claims. You can minimize your damages. You can really save a lot of time, headache, costs, insurance policy monies by having a wonderful contract. So again, you submit your proposal with great language, you incorporate it into the contract if your client has a different contract. Now, if you have a great contract, hey, perfect, that works for you. Watch for any kind of provision in your client's contract that supersedes, overrides, takes precedence over any good contracts provisions you have, either in your contract or through your proposal. That's what this is about. So here are some of the top contract clauses. Again, each one of these we'll touch upon briefly. These are things to look for: indemnity, defense, in particular duty of defense, consequential damage waiver, limitation of liability, sole remedy, third-party obligations, standard care, warranties and guarantees, and dispute resolutions. And we'll touch upon these items here. So indemnity. Some of you may have seen this, indemnity. It's a critically problematic provision that we see all the time. You get your nice proposal, the contractor, the owner gives you a contract back, and guess what? There's this provision in there that says, you will hereby indemnify me, the owner, our agents, our board members, our XYZ. You can almost say anything under the sun. And you have to, when you do contract analysis, watch for those provisions. Now, we put this little kind of visual presentation of some of these priorities that you must be looking for. Indemnity is always the first one you look for. That's a buzzword. If you see that word indemnity, perk up. Wow. Okay. Then you read it. Another one, you see the next one as it kind of goes down, is defense. We're going to touch upon that. Actually, out of the two, defense is more problematic for most of our clients than you imagine. And then you go down to, okay, now you see indemnity, you see defense. Then you start getting into benefits. Here's a consequential damage waiver, limitation of liability, define standard care, and then everything else. So you can kind of see how we built this little model here. And again, I apologize for the screens they're reversed. But if you look at the handout, you want to take this in priority: indemnity, defense, and then you look for benefits. Where can I stick in great language? All right. So again, this is just another way of saying the same thing I just said. Key provisions you want to note in the contract. And so we go to the next one, indemnity and defense. You're going to hear a lot of this because it's very important. They always tend to be brought in the same provision. Now, you say, okay, defense, what is he talking about, right? Indemnity, everyone kind of heard of. Defense is kind of a sneaky little piece of language that's inserted in an indemnity provision. Essentially what it says is you contractually agree to defend your client in claims that are brought either against the client directly, or in some cases, if the indemnity provision, defense provision is written appropriately, even for the client's own negligence. And so it is very difficult, and we emphasize, when you see the word defense, you hereby agree to defend, indemnify, hold harmless client XYZ. And we'll pull out later in the presentation a provision you can look at. That's got to be something that's on your radar. So keep that in mind. It is the most litigated issue that we see contractually with design professionals and their clients. Again, this is indemnity, a definition that we put together. Essentially, it's a duty to make good any loss, damage, or liability incurred by somebody else. And in this case, typically it's your client. So in other words, your client can claim reimbursement either through direct damages or even attorney's fees and costs, legal expenses. They can seek it through this provision and they can get that reimbursement. So you can go to a lawsuit, and specific to indemnity, if you go through the lawsuit and you defend, or you are in the lawsuit and you get to the end of it and your client is found liable for damages that result from your professional negligence, there is the potential for the client to shift. Again, remember earlier I took that example, can shift the full set of damages and responsibilities onto you. So you end up paying for him. And in a court of law, they can enforce an express indemnity provision against you, meaning the court could say, okay, not only you have to pay for these damages, you have to pay that guy's lawyer. And you're, what? You know, depending on the indemnity, you might have that obligation. This is a case that we talk about, George Brown Insurance. This talks about the indemnity. Again, this is getting kind of into the weeds with some of the legalese, but essentially in the state of Nevada, there is a law that says if the client wants to seek indemnity for its own negligence, meaning the client messed up and the client has this broad stroke indemnity provision, under these cases, the client is not able to seek recovery for its own indemnity. This is just one of these cases that talk about it. So when you see the term any and all claims, if you see the bottom bullet point, any and all claims, that's a good giveaway that the court will limit that exposure just to damages that resulted other than through the client's own negligence. But if the client is smart, he will have a lawyer that puts in specific language that says, not only you indemnify him from any third party's claims that are brought, but you also have to indemnify the client for the client's own negligence. So be very careful of this indemnity provision language. We touched upon defense a little bit. Essentially, defense is, as I said earlier, where one party agrees to defend the other party from future claims or lawsuits. This is a headache for you, okay? At the beginning of a case, you can have a client with this provision send you a nasty letter saying, hey, there's a defect in XYZ project. You have to defend me. You have to pay for a lawyer to come defend me for this issue based on this provision. 99.9% of the cases we've been involved in, our clients say, no way, I'm not defending you for various reasons. But defense is tricky, and this is why we always recommend you strike this language. You have to strike it, because if you do not, and we're going to touch upon it a little bit further down in this slideshow, but if you do not, there is the potential where a defense can be ordered even if you didn't do anything wrong, okay? And we're going to talk a little bit more about this, but I want to give you that heads up right now. Okay, so this is the dichotomy. The reason we have these two together is they're always in the same kind of similar provisions. There's always one provision that has both of these obligations. So we put this little kind of visual descriptions, indemnity versus defense. So courts look to the intent of the parties when they construe indemnity provisions. And then the opposite side of defense, the courts will consider when that language is in the contract that you agree to assume the defense, the responsibility. That means either you have to provide an attorney, or down the road, an attorney fees and costs that your client incurred can be brought against you. So be very mindful of this. Okay, here are reasons why you don't want to do this. Professional liability carriers do not insure you if you assume by contract to defend your client. Okay, now we always see this and it drives people crazy. Something called additional insured. There's additional insured, do you see that? That's a common contractor subcontractor provision. Additional insured should not ever be in a design professional contract, excuse me. If you see that word, strike it, because your carrier is never gonna pay it. And frankly, you don't want to be on the hook for these obligations, such as an additional insured obligation. You do not want your professional liability carrier to reject any kind of damage that arises from additional insured or any kind of a defense obligation that you forgot to include in your contract. Remember, professional liability carriers insure you for liability arising out of your negligence, not all acts, errors, or omissions. And in this case, this is a contractual obligation. You have to be very careful not to assume that responsibility. So what you want to do, what we typically recommend you do, is when you look at the contract and you see indemnity and you see the word defense, you want to strike that. You cannot allow that contract to go forward. You must strike it. You must tell the other side, look, if I do not strike it, the carriers are not going to cover it. And if they don't cover it, that means I have to cover it. Well, I'm not this big, 100, 200 person company. Usually a lot of you guys are within a certain smaller segment of responsibility. And one of the things you can say is, look, this, I can't afford to have, especially one of these massive multi-million-dollar cases. I can't afford to cover your attorney's fees and costs, and especially attorney's fees and costs can be significant. I mean, in a multi-million-dollar case, you can see hundreds of thousands of dollars. You can even see millions of dollars. It's not unusual. So be very careful. You see the word defense, strike it, strike it, strike it. I can't emphasize that enough. And again, this is another slide that talks a little bit more about the items I just mentioned. You do not want to take on this responsibility. It can run into significant funds, and that's funds that you may end up having to pay. Now, we are very good in cases where you do accidentally sign the wrong contract. We're very good at resolving contracts through multiple formal, informal dispute resolution, through aggressive motion practice in eliminating cases, even where our clients accidentally sign a contract with a duty of defense. And if you prevail, it puts us in a very good position. There are other tricks that we have that will help you, but I think you help yourself the most by being very aware of this provision and very aware of the defense issues, particularly the word defense. If you see that anywhere in your contracts from your client, strike that and then explain that, while I would love to do work for you, I can't assume this responsibility, especially with this kind of fee. Contractors and owners have large damages, especially do a big project. Even a small issue can be a very large dollar amount, and attorneys, their expenses can be significant. So be very careful of that. Another case, this is Rayburn. We talked about the duty to defend triggers when the complaint is filed, regardless of liability. So typically what you will see is a letter from an attorney saying, hey, under XYZ contractual provision, you have a duty to defend my client or defend me if it comes from the entity itself. In the state of Nevada, remember, it triggers from the onset. Does not trigger when there's a finding of liability, okay? That's a critically important issue. And like I said earlier, you may not even be responsible. Isn't that a kicker? You win the case and say, yes, goodbye. Next thing you know, you see a motion. Well, they had a duty to defend. They didn't accept that duty. I should get my fees and costs. Now, again, this is an extreme example, but it is a possibility. And that's why the defense issue, we're spending a lot of time here today talking about that. So be very careful. The next case, this is a California case. And the reason you're saying, wait a minute, we're in Nevada. Why am I dealing with a California case? We thought this case was actually a lot of right on point on some of the issues we're talking about, the indemnity and the defense. Now, California is different. They have different requirements. And so I'm not going to get into California law. But what I am going to talk about is this UDC CH2M Hill case out of the 6th District Court of Appeals in California. And again, not to get too far into the weeds, essentially the HOA sued the entity for defects, negligent planning and design. CH2M Hill provided engineering, and apologize if anyone's from that company on here. They cross-complaint and then ended up for indemnity, and then they tendered their defense. That's the buzzword for defend me. And there were some settlements, but ultimately went to trial. They stipulated that the jury could decide the factual issue of negligence and breach of contract, but the court would decide the contractual indemnity provisions. And in this case, the jury came out, no negligence. Wow, we won. This is a defense verdict, right? And so the entity urged the court to apply, this is another case in California called Crawford, on the duty to defend and hold CH2M Hill responsible for immediate defense on tender. So this is the example. This is the actual case, what I gave you the example earlier about the difference where you go to a case, you win, you're congratulating yourself, and then they pull this stunt. They go to court and say, well, wait a minute, you have a contractual obligation to defend. And so there was some arguments how Crawford was distinguishable and that the indemnity provision was broad. But the ultimate finding is CH2M Hill's indemnity obligation was conditioned on the finding of negligence. So they didn't have an obligation to indemnify their UDC. Okay, so they won. Congratulations. This is it. They did not have an obligation to defend, strike that, indemnify UDC. However, here's the kicker. Defense obligation, when UDC demanded it, rose when the cross complaint came up and applied responsibility for the HOA's damages to CH2M Hill's deficient performance. And the HOA's, we call it generic or general allegations, was sufficient to implicate his work. And so the Court of Appeals found that that even if ultimately, even if CH2M Hill was successful, that the duty to defend triggered and they had the obligation to defend. So they affirmed the trial court's order, which included an award of fees and costs. And CH2M Hill was ordered to pay $150,000, even though they won, right? And then there were other issues such as a prevailing party provision and costs, a duty to defend. It added another $400,000, give or take, and the total amount was over $500,000. And we put ouch in there because we can't emphasize this enough. They won. They went to trial and won, yet they still get hit with a very sizable damage award based on this duty to defend. So what can you do? You scared me. I don't know what to do. You're lawyers. You know this stuff. I'm just a great designer. What do I do? Oh, that's a good question. So the reason I brought this up is this is a long, I'm not reading every word here, but this is an example. You can look at your packet later on, and you can see where we took a provision from that contract and we modified it, and pay particular attention on the bolded section. So it says, and I'm just going to point to that part. The consultant agrees at his own has his own expense upon written requirement by the developer or owner of the subject property to defend any suit, action, etc., brought by the developer owner. So this is the original language that dinged CH2M Hill. Okay. This is what we did. This is how we took that language and modified it. So again, we could spend hours on this, but let me just focus on the part that I highlighted. You can see how we took out that problematic language, the defense language. That's the thing that zinged them for $500,000. And we changed that. And again, look, this is not intended as a catch-all or the language you use for every contract. We're just trying to give you an example of how a lawyer, or with an understanding of the potential implications of a duty to defend, you can modify a problematic provision. This is just an example. We are not recommending this for any particular specific contract that we've never reviewed. This is not legal advice. This is just an example of how you can modify a problematic defense law obligation and say, look, in this case, we changed the language to say consultant shall have no upfront duty to defend. Okay, that takes away that problem of getting that notice and starting the clock for fees and costs. And then shall reimburse defense costs to the extent of its indemnity obligation. So in this case, if this language existed in the contract of the case we just discussed, guess what would have happened? The court would have looked at it and said, oh, well, wait a minute. CH2M Hill, you weren't found liable. You had no indemnity obligation at all. You have no obligation to indemnify. By extension, using this language, you have no defense obligation. So again, this is not the Bible. This is not intended as a catch-all piece of language. It's just to give you an example. And again, this is some more of that language we talked about. The key word is upfront duty and reimburse subject to indemnity. So if you're not found liable, you don't have to pay defense costs. And again, you can refer to the documentation. So this was kind of a interesting question. What can you do when your client's insisting? We want this. We want you to do everything. You want the project, you got to sign this, right? Sorry, there's no easy answer. However, you do have a right as a professional to negotiate a fair allocation of risk. You should have this discussion with your client when they insist, because some lawyer that they hired wrote the worst provision ever that benefits their client but not you. You need to have kind of a discussion with yourself and your clients. Is this fair? Do I get a $10,000 project and be exposed to millions? It really is. A lot of our cases, the fees are never the same as the risk. So you get a small nominal fee and you got to put up a policy that's $1 million, $5 million, $10 million, depending on the project. And then they put this excessively onerous provisions. You don't want that. You have to have a conversation and say, what is fair? Okay. And some of those we'll discuss as moving forward, but you got to have this conversation. You also got to have conversations with yourself. Do you need the job? How badly does the client want? Remember, you have leverage too. A lot of your clients are coming to you because you did successful projects in the past, or you have a reputation. We'll use that to your advantage. Make sure that your clients, if they really want you, they're going to work with you. If they don't want you, or they're just going around getting proposals from 10 different firms, they're going to insist on their language. And then you put yourself at jeopardy. So these are some of the questions you can ask. And most importantly is the bottom one. Ask. Ask, ask, ask. If you don't ask, you don't get. Other things. We always in a lawyer presentation say, talk to your lawyer, talk to your broker, talk to somebody who has knowledge of these things. You guys are great designers. You can, I can't draw a stick man. You guys can draw wonderful, beautiful buildings. But this is where a lot of our clients tend to find themselves in a situation where they signed an owner's contract. And you know what? They signed it because they wanted the project. The owner insisted, or sometimes it's as simple as just sign it. Oh, wow, I got this. Wow, great. I got this project. Just sign it, sign. You need to take a step back and make sure you can negotiate a contract. Now, I know many of you do. And some of these are non-negotiable provisions. We understand that. Strike it. That's our first thing. Strike it. As you see this kind of problematic language, strike it. Or you can do alternatives. Suggest some sort of a bifurcated indemnity provision. Eliminate the defense obligation, or maybe just apply it for general liability issues, not for professional liability. In general liability, you'll see additional insurers. They can approve certain, and again, I'm not an insurance specialist, so I will put a caveat out there. Talk to your insurance broker for more detail. But these are suggestions. Again, these are options that you can consider. And we define a bifurcated, essentially, bifurcated indemnity clause means two separate clauses where you provide a defense to your client for claims outside of professional liability, but not for inside. In other words, professional liability, consider it as kind of a severed area. And again, this is more of things you can refer to in the handout. The next provision we talk about is something called consequential damages. Again, very important. You want to have in your contract a waiver of consequential damages. You sign a contract, you go do the work, there's a defect, okay? Let's say the defect isn't much, but it stops the work. So now you have a defect that maybe is a couple $100,000 on a multi-million-dollar project, and you stop the work for 3 months. And this project needed to be open on such and such date. Let's say this project had customers and they estimated millions are lost simply on delay. That's what's called consequential damages. Losses that don't flow directly from the defect, but flow indirectly. The most obvious one is delay. If your design causes a delay to the project which impacts its completion date, and you have a customer with a client with a lot of customers, guess what? You're getting a bill, and the bill is going to be a lot of money. So what you want in your contract is a waiver of that. Get rid of it. We find that this provision is hilariously, a lot of owners that are even sophisticated don't catch this, don't catch the waiver. And so because they don't catch it, you can get away with striking it. And it's, oh, I don't care about that. But realistically, given the project, not all projects, but some of the bigger projects, this is probably the most expensive damage you can experience in the situation. So be leery of that. And again, this is more of some of my discussion. It's a protection of the expectancy interests of the parties. Essentially, the goal of consequential damages is to return the non-breaching party to a position that they were without the breach. So if you had a defect in your design that caused the delay and they're now 3 months behind, there is a calculable damage. And it's done by some high-priced consultant who's going to come in and obviously increase the price as much as possible. And it is foreseeable that we've seen in the courts. Again, if you breach your contract, you have direct damages. This is cost of repair, diminution, out of pocket. These are pretty standard damages you would see in any kind of professional liability action. Consequential damages, we touched upon that. These are damages that the breach party knew or should have known at the time of contracting that could happen. Think delay. That is the it's not the only one, but delay is the easiest way to conceptualize what this means. And then there are certainly other damages that can arise under law or statute. And again, here are some examples of consequential damages. I keep saying delay, delay, delay. Well, delay is the first one. But there's other damages like acceleration, lost profits, loss of use, loss of enjoyment, damage to business reputation, on and on. Essentially, it's a pile-on. If you have a defect at XYZ value and the owner can pile on to that, that really increases your damage exposure. So when you see this provision in your contract, or you can insert a consequential damage waiver in the AIA, there is a provision that says consequential damages are waived. You get your client to sign that, wow, a lot of the damages that you could potentially be exposed to are gone. Now, we tend to find this as very problematic in bigger projects. So for any design professionals that touch upon these bigger projects, we recommend that you keep an eye for this. You want it in your contract. It's a waiver, not an agreement, a waiver of consequential damages. Most contractors and owner entities don't really understand it that much if they're not sophisticated, and they may agree to it. And if you do, you eliminated all of these damages on this list here. And again, some more information. Again, we talk, and you might hear this throughout today, the allocation of risk. Insurance companies do that. We recommend you do that as well. If you are getting involved in a project in which your best collective fee is going to be $10,000 or $20,000, you should have good language protecting you from exposure from millions. We see it a lot. It's not a hypothetical. We see it all the time. Your fee is never going to match the exposure. So you want to have that control. And that's what contract negotiation is. It allows you to have the control at the beginning of the project of the risk. Now, most of you are going to have most of your projects be successful. You're going to get awards, and you're going to move on and do what you to the next project. But it's that one project. It could take just that one project where a few hours or a few minutes of time spent analyzing a contract will save you down the road. You never know. That's why you have professional liability. You never know when an error can arise from your services. And we tend to find that the fee is never the same. You don't get like a contractor would get millions of dollars on a given project. Let's just say the normal project is probably, your fee is less than, $1 million. I'm not excluding those huge resort projects. But then your risk is like $10 million. I mean, is it fair for getting a fee, say $50,000 fee, and your exposure is millions? It seems like insurance, doesn't it? And that's what these people are doing. They're putting this into the contracts and putting you guys in a difficult situation in a lawsuit where now your exposure is significantly greater than the amount you're paid. And so control that in the negotiation phase when you have that control. If a client wants you bad enough, they want you, you will have a lot of leverage to put in these provisions that will really save you a lot of headache down the road. Similarly, how do you avoid imposition of consequential damages, which could exceed your policy limits? The good news is, in most cases, we tend to find that even in the worst case where your exposure, let's say it's tens of millions of dollars, most cases will settle within your professional liability limits. The big exposure cases we tend to find sometimes, the plaintiff counsel will early on understand that chasing you to the ends of the world is not worth the time, effort, and cost. And they may do something called a policy limits demand. But if you sign a bad contract, just remember the leverage that they have against you. And in this case, ways you can avoid any kind of exposure. This also applies for direct damages, cost of defects. Don't make a mistake. Don't let anyone you hire, these are your consultants. And we're going to talk about that a little bit more because this is a very interesting topic. If you have a contract with your consultant and you are responsible for that consultant vis-a-vis your client, and again, this is a very general statement, but be wary of that. So don't make a mistake. You don't make a mistake. Your consultant doesn't make a mistake. And again, some people are like, wait a minute, I'm an architect. How am I supposed to know what my consultant, the engineer, is doing? Well, you got to have good communication. You got to hire the right consultants. You got to trust that their work product is reputable. That's all very similar to contract negotiations. It's also knowing who you're hiring. You can do all this, right? You could be 100% correct, 100%. You, 100% your consultant, and you still get sued. So we put in this little slide here. The easiest thing to do is, do you never make a mistake? Well, we're human. We make mistakes. Could you ever guarantee your consultant never is going to be 100%? Unlikely, right? Strike the consequential damage waiver. That is the easiest thing you can do to save yourself this headache. And that's why this slide's here. Just the example, client and consultant waive consequential damages for claims, disputes, and other matters in question arising out of or related to this agreement. This mutual waiver is applicable without limitation to all consequential damages due to either party's termination in accordance with the termination provisions of this agreement. Again, this is a very generic provision that you can insert. The AIA has one. You don't even have to put this much mumbo jumbo in there. The more important part is client and consultant waive consequential damages for all claims, disputes, or other matters and questions arising out of or related to this agreement. The very first sentence is generally what the language we see for this particular provision. Okay, some good news. Limitation of liability. This is your friend. This is what you want to have in your contract, okay? These, we talked a little bit about concerns, indemnity, defense. We talked about benefits to your client. Well, now let's talk, and we talked about waiving a benefit to your client. This is something you want to have in your contract. A limitation of liability is a provision where the parties agree your maximum damage for a claim related to your defect is capped at a certain amount. Now, in the state of Nevada, limitation of liability provisions are enforceable so long as they're reasonable, so long as they don't offend public policy. But 99.9% of limitation provisions we've seen are generally upheld because the limitations are not ridiculous. Like, you can't put in a limitation liability provision $1. Okay, my maximum exposure is $1. Okay, that's an extreme. Nobody's going to enforce that. No court will ever enforce that. But what you can do is put in a cap like my fees, 50,000 or fees, whichever is less, 100,000, depending on the size of the project. The court will look at the reasonableness based on the size. If you have a $100 million project and you put a $50,000 cap, the court's going to be very, very difficult in viewing the reasonableness of the cap. But if you have something like, a couple $100,000 on a $100 million project, those tend to get granted, So again, you gotta base it on the size of the project, especially these smaller projects. You can do it on fees. You can do it at like 50,000. We've even seen 25,000. But once you start getting low, like 10,000, 5,000, it starts getting less valuable in terms of being accepted by the court. So you want to be reasonable in the amount, but you want to have this if you can. And as stated, it's limited to a specific amount. You can limit to the greater, but we always recommend the lesser. That's what you want. So you want to have a cap number or fees, whichever is less. That way your max exposure is, for example, if you charge $100,000 for a project, it is not unreasonable to have a limitation liability of 50,000 or fees, whichever is less. Less means if you get 100,000, you're capped at 50,000. This helps you so much in a lawsuit where you can pull this provision out and the guy's suing you for millions and he's, whoa, wait a minute, my client signed that? And because of that, a lot of the clients will strike that provision. Please do your best to get it in there if you can. If you cannot, there's alternatives. You can cap it at your limit, your policy limits. And in this case, we gave you an example. You can cap it at your available policy limits. And again, this is based on the size of the project. If you have a huge project and you put this language in there, your exposure is your policy limits. You will never be exposed beyond that. And that's what you want to do. Here's some samples. Again, it's not legal advice. These are just examples of something you can refer to as a limitation of liability. Owner agrees to limit the liability to consultant, principals, employees, subconsultants, etc. Because if you have subconsultants, you want to have this fall as a general umbrella for them as well. And you can see in this case, it says whichever is greater. Some of that's negotiation. Sometimes the owner may not agree to lesser. They may agree to a cap that's greater. These are just some you can negotiate. Limitations on the limitation liability, some of that we talked about. We call it a life preserver in a shark infested water. Attorneys are notorious for that. And if you have this kind of protection, think of it like a big wall. They can't get at your assets. They can't get at your limits. They're capped in their exposure. Then guess what? They're not going to chase you. You know, if it's a big enough defect, they'll settle early, maybe take the limitation and call it a day. If it's too much of a difficulty in getting past this, and they may not bother you. You may not even get sued because of this provision. It is only enforceable between the contracting parties. Okay, so be careful. Don't have a limitation liability and say, well, John said I'm capped. And you get sued by somebody who's not a party to the contract. In that case, the limitation liability only will apply to the contracting parties. Now, earlier we talked a little bit about indemnity and defense. I told you the negative of that. The positive of that is you can actually flip that and use it to your advantage. And I apologize if I didn't bring this up. All of the bad things I told you about the indemnity and defense that your client can use against you if it's in their contract, you can do the same thing to your client. You can make your client defend you. You can make your client indemnify you. Now, when you add it with this limitation of liability provision, there is a strategy where you can say, okay, I want a cap on my exposure, and then anything above that, you, client, have to defend and indemnify me. So let's say you have a $10 million claim, you have a $200,000, $250,000 limitation liability. You say, I'm responsible the first $250,000. I will pay that. Now you, client, under this provision, the defense and indemnity provision, you have to pay the rest. And these are kind of contractual negotiation strategies that you can implement. We're just throwing it in there as a topic of discussions. Again, here's something that I think is critically important as we shift now to other contractual provisions, sole remedy. I don't know if most of you know this, but you can be personally sued for errors and omissions in any of the plans you stamp and seal. And that's even if you're acting within the course and scope of your employment or within your corporation. We don't see this a lot. We see it once in a while with a clever plaintiff counsel. He will sue your company and he'll sue you individually. And he'll sue you, excuse me, he'll sue you individually under some Chapter 623 obligation. It's very clever. It creates leverage. It creates stress. Now, your insurance policy will cover both of you, your company and yourself, but it does create difficulty because when people are personally sued, it's personal, right? There's stress. Oh my God, what can happen? Do I lose my livelihood? Do I lose this? Do I lose that? You know, as opposed to a company, well, the company got sued as a company. And the reason we bring this up is they're not limited to just suing your company. They can name you and name you personally. And this is a strategy that they can use to drive up your stress and force you to settle on their terms. Okay? So this becomes a problem if you focus on the middle part, right? If your corporation is sufficiently insured, you have high enough limits, you have enough assets, this isn't really much of a problem. Yet it's still painful. But if you have a high policy limits, the insurance company will cover you personally. So they'll treat your company and you as the same. They'll defend and indemnify you, and they will certainly, you have the benefit. But what happens when you're not insured? What if you have a $1 million, $2 million aggregate policy on a project that has $5 million in damages, and you have been a very successful design professional, you have a nice house, nice assets, you have maybe side companies. This is the problem. If lawyers are always going to look for money, and especially if their damages are significant, they will look for any other pot to come from. And most importantly, if they can sue you, they could put a lot of pressure, especially in a large damage value case. They can put a lot of pressure on you. This is what you want to do. You want to have a clause or provision in your contract that says that your client's sole and exclusive claim, demand, suit, judgment, et cetera, is not going to be against shareholders, architects and engineers, directors, officers, employees, just the corporate entity. That's what sole remedy means. Meaning, if you're going to sue me, you just sue my company. You don't sue John Q. Architect. Okay? You want this. This is, again, similar to limitation liability. You want this in your contract. Moving on, third-party obligation. All right? Third party, what's that? What's the issue here? Third parties are parties that are not parties to your contract, but claim that you owe them under some sort of an independent duty of care. You owe them some responsibilities, and they'll sue you if they can. Okay. We said in the very final example, it's usually a contractor, usually a contractor that you have nothing to do with. And believe me, they will sue you. Yeah. And of course, we got ways to get you out of that, but they will sue you. It's a headache you don't want to do. So again, in your contract, this goes again back to the limitation liability, sole remedy. Here's a sample third-party claim waiver. Nothing contained in this agreement shall create a contractual relationship with or cause of action in favor of a third party against either the client or the consultant. In this case, we wrote it to be favorable to both your client and consultant. The provision is designed to protect you from third parties that are not part of the contract but want to sue you for your scope of service. And again, some of that can be eliminated through something called the economic loss doctrine that Mr. Kilber will be discussing later on. But for now, if you have this in your contract, no one can sneak into your contract and claim some sort of a right against you. Again, this is a sample, not legal advice. You can take a look at this. There's other language that you can utilize. Okay, so I think this is where Mr. Kilber will take over the presentation. And I'll try to actively stay on questions you may have, so keep them coming.
So standard of care is typically set by the region, the location where you are. It's, what a professional is doing in the same discipline, in the same location, around the same time. So that's what you're being compared to when they're trying to determine whether there is some sort of breach of your contractual duty or whether you made an error or omission. It's compared to what other people in the field are doing. And oftentimes you will see in a contract that the standard of care will be defined, and you want to make sure that when you're negotiating what the standard of care will be in the contract, that you do not give yourself a heightened standard of care. You don't want to use words like first class services or the best quality, or it should basically mirror the language of the standard of care provision, should basically mirror what was on the last slide, and just say our standard of care will be performing our services in the same manner as someone in the same locality would provide for this type of project. And that way you're not exposing yourself to some sort of heightened standard where they expect you to be extra diligent or have a greater responsibility to identify or stay within your standard. So the standard of care, mistakes happen on projects. There's no such thing as a perfect set of plans or perfect specifications. You're going to have issues come up during the course of a project, especially on fast track projects, where you're going to have to provide redesigns. And so the standard of care does not require that you make 0 errors while you're performing your services. It's really what the average designer in your field of work would do on a project like you're doing. And this is what we just talked about. You want the highest, always clients will ask you to agree to a higher standard of care so that they can try to slide in more claims because you didn't provide the highest standard, the first class, the world class. In addition to that, your insurance carrier is not going to cover that heightened standard of care. They're providing you insurance to cover standard errors and omissions that would occur under your ordinary standard of care. So if you agree to a heightened standard of care and it's shown that you did not perform to that heightened standard of care, you might go without coverage and unlimited liability for that higher standard of care. So what can you do? When you're negotiating your contract, don't promise to do anything greater than what the normal standard of care is because it's not insurable. And then again, this is not legal advice, but this is kind of a sample of what we would recommend providing as a standard of care language in your contract. And it dovetails in a little bit with warranty, and we'll get into warranty a little bit later. All right, here we are, warranties and guarantees and certifications. Most of the time you would look at warranties to address issues coming from injuries or damages related to a failure in a component implemented into the project. It's very difficult to insure or warrant a architectural design, because once you create your design and put it out into the world, there's a lot of people who have an influence on how that's incorporated into the project. And so if you're trying to, if an owner wants you to say, I want you to give me a warranty that if your plans and specifications are followed, you will be responsible for any defects that exist based on us following your design. And there's just too many issues that can come up on site during construction that you can't control. And so anytime you have an opportunity to strike warranty language or limit the scope of the warranty, you need to do that. Our first line is to strike the warranty and any language that references any type of warranty, because it's simply not something that you can control. You can't control the outcome of the project. Next slide. So the type of warranty that perhaps you would see in a contract is that you will comply with statute. So if a statute requires a certain thing in your design, you'll warrant that you would have that in your design. That's one instance where you would see perhaps a warranty language try to be used in your contract. So oftentimes during litigation, we get claims against our design professionals for warranty because of the warranty language in the contract. And they'll basically say, you know, we hired you as the architect, the expert on design. And so when you created your design, we expected that to be fully functional. It would work as put on paper. And if it fails, it's your fault. And that clearly isn't always the case, especially when you have contractors who are going outside the design to implement their construction means and methods. So the bigger problem, sometimes your client's going to ask you to expressly provide a warranty in your contract, and it's basically a backdoor way for your clients to ask you to perform at a heightened standard of care. And so if you're good about defining your standard of care in the contract, but then you agree to a warranty or a guarantee regarding your services and the quality of your services, then that standard of care might go to the wayside, and the claimant will say, you said you would provide this certain quality and you didn't, and you're in breach of the contract now because you're not warranting your service. So what's the solution? You have some solutions. So as I said before, the best way to proceed is to strike any warranty language from the contract and explain that you can't make a promise on the outcome of a project because it's out of your control how it's built. In addition, you could go further and not only strike the warranty provision, you could also include a provision that expressly says you're not warranting your services. All right, and this is just talking about certifications that you provide. They are similar to warranties and guarantees, so watch out for certification language. Watch out for when an owner comes and asks you to certify or assure that some component of the project is complete or is at a certain quality or standard, it's best again to just leave out any language with respect to certification if you can. Again, here's some sample language where you identify what you mean by certify if you are asked to certify something. Okay, the economic loss doctrine. This is a topic near and dear to our hearts as defense attorneys for design professionals. In Terracon, which was a seminal case in Nevada, the Nevada Supreme Court determined that you cannot be, if you have a contract, you cannot be sued by third parties or for tort for claims arising from that contract. So oftentimes you'll see that third parties or an owner will attempt to assert claims for negligence or other tort-based claims like indemnity, contribution, and they're going to ask you, and these are equitable indemnity, equitable outside the scope of the contract. They're going to say, we're owed something because you messed up, and it could be above and beyond what's in the contract. Well, under the economic loss doctrine, the courts in Nevada have determined that once you have an executed contract, the remedies that an owner or the person you contract with are limited to what's within the four corners of the contract that you negotiated. And that is very helpful, because if you are able to get in the provisions that we've talked about previously in our presentation today, you're going to have a very strong contract, and it's going to limit the scope and ability of a plaintiff or a claimant to attempt to recover damages from you. And they're stuck with what they negotiated in the contract. And probably the biggest thing about the economic loss doctrine is anyone that you didn't contract with can't bring claims against you typically. Now, there are some exceptions to that. If there's a personal injury, the courts have excluded those claims from the bar of the economic loss doctrine. So if there's a claim arising from a project where you were the design professional and a component of the project failed and injured that person, typically you wouldn't be able to be sued by anybody but your client. But in that instance, the injured party can bring a claim against you. And that was done so to protect the rights of injured people. The second caveat is homeowners. Under Chapter 40, if a case is brought, homeowners who didn't have that privity of contract with you, typically the homeowners will contract with the developer when they're purchasing their house. They don't contract with the design professionals. Under that circumstance, again, the legislature and the courts in Nevada have determined that homeowners need to have as much protection as possible, so they can directly sue design professionals even if they didn't have a contract with you. All right, dispute resolution provisions. So there's a lot of different ways that we can try to attempt to resolve claims, and often the best way to, and the most cost-effective way to resolve claims is to include reference to what types of dispute resolution the parties agree to before there's a problem. There's mediation. In mediation, you use a third-party neutral person, and the mediator will listen to your side, they'll listen to the other side, and then using their experience and knowledge, they'll try to negotiate a reasonable resolution between the parties. Most often than not, it's non-binding, and so you can go to a mediation, try to negotiate a settlement. If it doesn't work out, you move on to the next stage of the dispute resolution provisions. Typically, an arbitration or litigation would follow mediation. It used to be that arbitration was a good way to proceed for dispute resolution because it was a faster and more cost-effective means of getting a binding resolution to your case. However, over the last couple of decades, arbitrations have become corporatized and have become onerous, and oftentimes you can get dragged through an arbitration for a significant amount of time because an arbitrator will not typically let parties out of a case early on in the case, because the longer a case goes on, an arbitrator makes more money, and so they would be cutting off their own means of making a living. And so we've been starting to recommend that if an arbitration, if the parties want to use an arbitration provision in their contract, you should figure out what source of arbitration would be the best. There's AAA, there's JAMS, there's private arbitrators, and you want to look at, what would be the fastest way to get this done? What type of arbitrator? Should we use a corporate arbitrator? Should we use a private arbitrator? That's something you would want to talk about when you're negotiating the contract, so that everyone's on the same page with respect to who's going to manage the arbitration and how they're going to split the fees for that. But oftentimes now, litigation, the courts are, with COVID, the courts are slower again, but prior to COVID, the courts were getting through cases pretty quickly, and it gives you more options to resolve cases in the litigation pipeline. You get more chances to negotiate as the case goes along. And so these are common provisions that you would want to put into your contract so that everyone knows if something goes wrong, what the start of trying to resolve it is. And one other dispute resolution type that we didn't add in here is meeting between principals. We find that a good condition precedent to mediation or arbitration is to have the principals of the owner and the design firm sit down and see if they can work out their claims, so that it doesn't even have to go to mediation. It doesn't have to go to arbitration. In fact, it can typically keep lawyers out of the mix in general. And so that might be another option to add as a means of dispute resolution. Next slide. Next slide. Again, so you can have, when you're negotiating your dispute resolution process, it typically is a stepped process. So the first line of resolution would be the meeting of the principals. If that doesn't resolve it, then you would have a notice requirement for mediation. If it doesn't resolve a mediation, you go to arbitration, and then you would either try arbitration or litigation. Yeah. A lot of times, if you're in a contract that has flow down provisions, you'll notice that in the prime agreement, there would be some sort of arbitration provision that says everybody needs to agree to arbitration, and your downline contracts need to include a provision that says everybody needs to be on the same page for arbitration. If it's at all possible, you want to avoid those type of flow downs where you're getting dragged into an arbitration, because there's instances where you're going to have an owner and another general contractor, and they're in a big dispute, and they could get that issue resolved in arbitration without you, but because you've agreed to participate in the arbitration, you could end up getting dragged into the arbitration. So again, it's always, if you can avoid having a flow down provision that requires you to participate in the dispute resolution, even if it doesn't involve you, try to get that struck. Okay, I'm going to give this one to John for mechanics liens.
Yeah. Okay. Sorry about that. I'm trying to close out my screen, guys. Give me a second. Sorry.
It's right there.
Where's that?
The X. Right there.
Okay. Technologically challenged. This can take a full day to explain. Nothing today is intended as a deep dive on these topics. It's just a very broad overview. So, mechanics liens. Some of you have knowledge and experience with this. I'm not going through every little nuance of this. This is when the guy doesn't pay you. You have a contract. He doesn't pay you. What do? Well, you threaten him, right? Yeah, I'm going to get a lawyer. He blows you off. Contractors have this favorable provision under NRS Chapter 108. It's generally used by contractors. It favors contractors, to be blunt. But it states essentially you can file a notice of lien with the county recorder within 90 days of the following three: completion of work, last delivery of material and furnishings, last performance of services. You have a project. You complete your services in July. You have 90 days to file this thing with the county recorder. Critical. You blow the 90 days, you cannot bring a mechanics lien against the owner of the property. You can bring other claims, like breach of contract is 6 years, for example. It doesn't mean you can't bring a claim, it just means you can't bring this claim. So I encourage everyone to focus on NRS Chapter 108, the mechanics lien, if you do mechanics lien law, or if you intend on implementing mechanics lien for projects that are not paying you. Be weary. Again, this is just talking about very critically important deadlines. They have very stringent deadlines, and you blow it, you blow it. I'm sorry. 90 days under one of these dates. And last performance is the easiest way to prove is through invoicing. If you provided services in July, you better be filing this within 90 days. We tend to find that if you come after the 90 days, you're not going to be able to bring this. There are some other nuanced differences. For example, in residential, you have to do a 15-day intent to lien. You must do that, or else you will not get the benefit of the lien. You must record in compliance with statute. This is critical. It is very, if you blow the requirements, you're not going to get the benefit of this. You must serve notice within 30 days after recording the lien. You cannot bring frivolous liens. I'm going to very stress this to many of you. You don't get every dollar you think you should get. You get what you're entitled to get. But if you start tacking on millions and millions of dollars, and a court of law views that as frivolous, you can be sanctioned severely. So make sure when you do the lien, your numbers are correct. Have good accounting, good numbers. And these liens are only good for 6 months. So it's not like you file it and then walk away. You have to bring an action to enforce the lien within 6 months. If you don't, again, very similar to a 90-day rule, you are unable to bring a claim under this statute. You can bring a claim for different reasons, but not under this one. This is a sample. This is taken straight out of the statute. This is what it should look like when you file your notice of lien. Now, again, refer to your handout for this, but this comes straight out of the statute. I even cite it, 226, sorry. It may be difficult to see, but this is the general information you should have. I cut and pasted this straight out of the statute. So this is what your lien should look like. Some variation is acceptable, but it should have these items in there. You should have your name. It should be notarized, and it should contain the information that's contained in items 1 through 8. This is just a sample, again, straight out of the statute, cut and paste, nothing exciting. I wanted to bring this up because lien law favors contractors. And it's frustrating as design professionals that you're not really considered, when comparison to others, top of the food chain, if I can use that term. Under this statute, and again, this is straight out of the statute, liens are viewed differently. The courts will apply, and generally speaking, when you do file a lien, you're not the only one. There's usually a lot of other contractors, subcontractors, material providers. They're all filing liens because this is what they do. This is their scope. This is what they utilize. So when you join the party, just understand that you're not ranked really high there. I mean, it first goes to labor, material suppliers then, and then other lien claimants who perform work in whole and part under the contract with the prime contractor or any subcontractor, and finally, all other lien claimants. Well, guess where you fall? Most likely in the fourth category. So these other guys will get their monies first. Now, no one ever really recovers a dollar for dollar. If there's a project that's falling apart, you're generally going to recover cents on the dollar. But again, this is a mechanism you can use. You have to be cognizant of the deadlines. And lo and behold, the biggest recovery person is the actual mortgage holder of the property. But again, this is what you can recover if you do bring the notice of lien and you're successful. They can award to you the amount that you requested. Again, very rare that you get the full dollar amount, but you get some percentage recovery, calculated interest, and certainly if you put an interest provision in your contract, the courts will enforce it so long as it's not, well, actually in Nevada, it's pretty flexible. They'll give you a lot of interest, but if you have an excessive amount of interest, the courts may not enforce that. Again, this comes straight out of the statute. This is what you can recover bringing this type of claim. Okay, that's, like I said, that's a very quick overview of mechanics lien. I know a million of you are going to have a question about it. Just understand that the key points I wanted to get across were the deadlines, the form you have to use, what you can recover, and making sure that you comply with the requirements of Chapter 108. And then if you could do that, you have an avenue for recovery of your damages. If you blow any of that, don't worry. You can still bring a claim under breach of contract. That doesn't preclude your right to seek any other type of recovery.
Notice of right to lien.
Yeah, we already talked about that, yeah. Mr. Kilber has asked me to make sure that I emphasize, and I believe I did. If I didn't, I apologize, but I believe I did. For residential projects, you do have an obligation to do a notice of right to lien first before you can do the lien. So keep that in mind. But again, this alone could take out an hour of presentation. We're not here today to do that. I want to move on to something that's like COVID-19. And this is a little bit, we're all living it. It's still kind of unsure how this is all playing out. We haven't run yet into a case involving COVID-19 particular yet. So again, this is, I got to be very careful here. COVID-19 is reality. We have to deal with it. So what's the issue here? In a lawsuit, all your job files, as long as they're not privileged, including emails, are discoverable. You have to be careful. And mind you, this isn't just COVID-19. I'm talking in general now. We have very general, broad strokes issues that you got to be careful of as an owner of a company. Remember, in a lawsuit, all damages, all emails can be discoverable. You do not want to have an email that contains an inappropriate comment either to a coworker or even to a client. Even if you know the client, and this is your beer buddy. This is somebody you've been drinking a beer the day before. You send that email and it gets produced as part of the litigation. That's going to come back and haunt you from many perspectives, but in particular lawsuits. Attorneys love this. They love to show emails. They love to show communication showing, somebody saying, oh my God, I messed up. Well, that's Exhibit A. Certainly everyone knows all the inappropriate stuff. That is not your personal email. Your work email is not your personal email. So be very careful of what you put in there. Be very careful of avoiding slang jokes, any kind of inappropriate comments about somebody's appearance, snide remarks, snarkiness, arrogant, anything like that. Understand that if you put that into an email, it can come back in a lawsuit and bite you. You don't want to badmouth your client, contractor, or subcontractor in email, because guess what? In a lawsuit, that can come back and bite you. The way we describe it is, imagine your email being blown up in Times Square, right? If you don't want that communication to blow up in Times Square and embarrass you, embarrass your firm, embarrass your practice, don't put it down. If you're upset at somebody and you want to write the worst email in the world, write it, step back, slide back like I'm doing, take a break, come back, reread it, and say, okay, do I want this blown up on Times Square? No, I don't. So be professional. Remember, emails are discoverable. Again, this is more just general topic conversation, other risk management issues concerned with. Know your client. If you're going to contract with your client and they don't have any assets, right? They're shells, LLC, fly-by-night operations, you could be left holding the bag, okay, if there is a problem that occurs and arises. We typically find in a lawsuit a shell LLC or an LLC, a single-purpose LLC is probably the most basic example of this. You contract with XYZ Street LLC. Well, XYZ Streets LLC has one purpose of existence, and that's to handle XYZ property on XYZ Street LLC. You go in a lawsuit against XYZ Street LLC. You win. You spend a couple $100,000 to win. You're prosecuted. Congratulations. You take your piece of paper. XYZ Shell LLC no longer owns XYZ property. Guess what? You have a nice piece of paper. You have nothing. Okay? Understand that. There are clients out there, single-purpose LLCs, or clients with no money. You gotta do some management or due diligence into your clients before you contract with them so that you understand. And this goes to your fees as well. If your client is a single-purpose LLC, your client has no assets, guess what? They're not going to pay your bill. You do all this wonderful work. You give them a set of drawings, perfect. Here's the bill. Sorry, I'm not gonna pay it. I don't have any money. Sue me. You sue them, you got nothing. So keep that in mind. We always recommend you do some due diligence on your clients. And again, this is more of the same. Choose your clients, reputable, stable. Somebody you can stand behind the project. They're adequately capitalized, insured, and they have realistic expectations, right? Custom home is notoriously bad for unreasonable expectations. They want the Taj Mahal, yet they only want to pay for, the track. No disrespect to track homes. Keep that in mind. Know your client. There's very simple things when you interview them, when you talk to them about the project. You can get some gut feelings. If a client has sued you in the past and has come back to you, keep that in the back of your mind. Do you want to do business with this person? And believe me, a lot of our clients do business, but you can so long as you put protections in place. Again, check with your lawyers. Sure your contract's consistent. Again, these are general management concerns you can bring up. Negotiate choice of law. Choice of law means we want Nevada law for a Nevada project to govern, not law from Florida. Choice of venue means we do the lawsuit in Nevada where the property is located, not Florida because it's in the contract. Some about tribal. Remember, you want to have some waiver of sovereign immunity. Tribal is different, and be careful of that. Insurance. Again, we're going to touch upon this very slightly. There's different kinds of insurance. There's project policies that are project specific. OSIPs, these are owner controlled programs. They usually do not include the design professional. RAPs are very similar to OSIP. These are different kind of policies that are available. If you can on big projects, you might want to consider getting a project policy that will cover your end. Again, this is not an insurance seminar, but these are different kind of policies that exist out there that you can keep in the back of your mind. COVID-19, I kind of went on a sidetrack a little bit earlier. Again, we have yet to see a major COVID-19 case, but be very careful of that. Have good policies and procedures to protect yourself and your employees. Follow the guidelines and requirements, ensure compliance and enforcement. We anticipate COVID will be the next large-scale class action lawsuit. So take it seriously and ensure that your clients, your employees, your interactions, and yourselves, you're all protected. Okay.
Force majeure provisions.
Yeah, if you want to, we can talk about that. So, all right, everyone, this is pretty much the topics. Again, there are a lot of them. We did this deliberately. If there are some general questions, we'd be happy to take them if you have them. But refer to our handout. If you have any specific questions, feel free to give us a call.
I do have a couple of issues just that we can touch on.
Okay, and then so Jeremy has some final thoughts, so I'm going to transfer it to him right now.
So I have a few notes that as we were going through, I thought maybe we should take a look at because they're important. When negotiating a contract, it's possible to negotiate how to trigger the statute of limitations and statute of repose to run. So if you can include in your contract a provision that says, upon this event happening, this will trigger the statute of limitations or statute of repose to run. That gives you an advantage because you can then hopefully run out the clock on the statute of limitations or repose because it was triggered earlier than what their attorney might understand. They might be thinking it's limited to what's in the statute, and you contracted and agreed to something that was a different way to trigger it. So again, that's something you might want to talk to. It's a more advanced kind of contract provision that you might want to seek legal counsel for. Another issue was we spent a lot of time on statute of repose and saying how it protects you long-term on a project. But one thing we didn't mention was the fact that statute of repose does not preclude claims for indemnity. And so if a party was sued in the case inside the statute of repose and a judgment was gotten, they obtained a judgment, one of those parties who you may have contracted with might seek indemnity from you after the period of repose is run. And normally you'd say, oh, well, the repose is run, I should be free and clear. But those indemnity claims, they have a different timing to them. And you can still be responsible for indemnity even though the statute of repose is run. So keep that in mind. We only have a couple minutes left, so I do want to, with respect to ADA, if you see any provisions in your contract addressing the Americans with Disabilities Act, if you're going to leave that in your contract or are required to leave that in your contract, please make sure you have an ADA expert working at your firm, or if you don't have an ADA expert in the firm, try to bring in a sub-consultant who can do that ADA work, because if you have that responsibility under your contract to comply with the ADA, it's going to be, even though there's good case law right now that precludes an owner from fully attributing ADA responsibility to you, you still want, you want to limit your exposure to those ADA claims. And the best way to do that is by having a consultant who will do that work, or by complying with the ADA, but knowing you're complying because you have an expert within your firm that is very well versed in the ADA. That's about it. I don't know if anybody else has any questions. We've been trying to answer them as they've come on. Oh, one final thing, I'm sorry, one more thing. Keep an eye on your invoices. If your project is getting out to, 100,000, 200,000, and your client hasn't been paying their bills, you really need to stop and look at, how do I continue on the project when there's this huge amount of money owed to me? And it's important to get in on that early on, start that discussion, start that negotiation process. It can be uncomfortable, but you don't want a project to get so far out ahead where there's so much money involved that trying to resolve that, it will end up with an owner asking you to take a discount on your fees. And so try to keep an eye on your invoicing as you're going through a project. Make sure you don't get too far out. I think that's the last issue I wanted to address with you guys.
All right, John. Jeremy, thank you.
That's it. Thank you, everyone. Appreciate it. We try to answer your questions. There's so many of them real time. If you have any other questions, please feel free to give us a call. Many of you know our office. If not, you can definitely